Welcome back to the Real Estate Momentum Podcast. I'm your host, Aaron Smith, and today we're talking about what's going on in the market with regard to who's selling. And the market shifted quite a bit. The people who are selling in today's market aren't necessarily the people who are move-up buyers capitalizing on their equity in homes and the low interest rates. Today's sellers are people who probably need to sell, and sometimes we're put in a situation where we've got to sell and we don't really know how to handle it. So I've got guest on the show today, Jodie Tharp with Holbrook and Holbrook Title right here in Kentucky. What's up, Jodie?
Hey, Aaron. Thanks for having me on. I'm Jodie Tharp. I'm with Holbrook and Holbrook. We've got offices Lexington, Fort Mitchell here, local, and then one in Louisville as well to help folks. We do 90% residential real estate closings.
Yeah, and you guys have done some closings for us so far. You haven't been in Northern Kentucky too long, but the time that you've been here, you guys have been crushing it. So thanks for
Appreciate
all the
that.
help there. And the last time that we were together, my team sat down with you, and you brought some things to the table that kind of talked about situations in real estate where we can help our clients. Maybe they lose a loved one. We talked about wills and what happens if you pass with the will and without. So we're going to open up that Pandora's box today.
Absolutely.
And there's a lot of situational stuff that happens with it. But we're going to talk for anybody who's watching or listening, how to be prepared for these things, what to do if they happen, and kind of do that, right?
Sure. Yeah,
So-
I think it's a great topic. Like you said, this is a life happens kind of market. Not a lot of people moving in the same subdivision that they live in, just looking for a different kitchen. Today's seller is, like you said, it's a divorce, somebody that's getting married, moving for a job relocation, or the unfortunate passing of a loved one and needing to wrap up the estate. So
Right. And a lot of times when life happens, there's a possibility for, well, let's back up for a second. For the last few years, I might have been thinking, okay, I need to sell my house, give ourselves about a 6 to 8 month window. Let's put some new carpet in. Let's fix the house up, and let's paint, and let's, freshen up the landscaping. When life happens and you end up with a piece of real estate that you need to sell, you don't necessarily have all that time, and sometimes you don't have the money to fix the house up.
Sure.
So that may be something that buyers run into, is that, hey, they're looking at a house that maybe not in bad shape, but it's not as in good a shape as if the seller were prepared to sell it.
Right.
Yeah. So
Sure.
I think, the last 8 to 10 listings that we've taken have been a situation where a loved one's passed away. We haven't done a whole lot of divorce lately, but it's been a lot of, hey, my folks are moving into assisted living, or, my mom passed 5 years ago. My dad just passed, and it's time for us to sell the family home. And it's not a pretty topic.
Sure.
But these people need help. So that's what I want us to bring to the people today. So let's talk about that. Let's say, for example, that you've got a person who's come to me as a client. You and I are working with them. What are you looking for if they've lost a family member? What's the first questions that you ask?
That's great. Both as a real estate agent or as a settlement agent, a title attorney, you become kind of a life coach in some of those moments. It's more than just about the property, and I'm sure you've experienced that as well. Really what you want to get a hold of is what's the situation currently. And then that, typically I recommend agents reach out to us or their preferred settlement agent and say, hey, can you just take a look at this for us? Who's the owner? Sometimes when you're dealing with a client that comes to you, they're like, hey, I need to sell a house. Well, is it your house, or are you selling it on behalf of your aunt or your mother? Or are they alive? Are they, like you said, moved into assisted living or unfortunately deceased? And once you get your hand around kind of what the current situation is, then we can kind of start planning next steps. And a lot of that, early and often is the key. When it comes down to the closing date, you don't want to find out about this stuff a week before you're scheduled to start signing paperwork. Some of these estates especially will have timelines that are established by statute or the courts. You could be looking at 30 days, 45 days in different situations before that closing can happen. So getting in front of those situations is your best bet.
Yeah, and so from a real estate agent vantage point, somebody comes to me, my first thoughts are, okay, did that person have a will? Because I can imagine if there's no will, well, now you've got to figure out, okay, who all's involved here, and you got to get the court involved and bring that open. My second question is there a mortgage on the property? And who's paying the mortgage? Is it set up for auto payment, or they're going to be late and you're going to get served a notice for non-payment of a mortgage? So I'm thinking about those things. So as far as you're concerned, let's see somebody comes to you and say, hey, family member passed away. There's no will. Okay, then what happens?
So you do have some options. In Kentucky and Ohio, both are very similar in the way they handle estates. There are a few little statutory differences, but the common law cases, the way it's kind of developed is very similar. So in an intestate situation, which is one where the deceased did not leave a will, so the parties are left to the state statutes essentially to decide ownership of everything, I'm still going to recommend opening a probate action in that case. Now, it's not legally required. Both states will have the option to file an affidavit stating the heirs. And the reason I kind of hesitate for people to do that is not always are probate attorneys thinking about the real estate. So you go to a probate attorney, they're just following the list of steps and doing a probate action, which is identify the heirs, file the probate action, and then you file the statutory affidavits in the land records with the county clerk's office saying these are now the owners of the property, right? These are the heirs. The problem you can run into that is sometimes those probate attorneys aren't checking the heirs for liens. So there are different ways to go about it. The way a real estate attorney or settlement agent would tackle a situation like that is, let's identify the heirs and then let's take a look. Let's give them the option. Do you want to sell this from the estate, which will involve a probate action, could take some more time. There's going to be an order from the court allowing the administrator to sign on behalf of the estate, and then there's a 30-day kind of appeal period, waiting period there before the administrator can act on that order. But what that does is it sells the property from the estate of the deceased as opposed to the individual heirs. And I'll use an example that came up recently in our office. A man was doing what he thought was right as the administrator of his mother's estate, went to the probate attorney, they filed all the necessary affidavits, he and his siblings become the owners of this property, and then they go to sell it. Well, in the title examination, it reveals he had some old credit, it was a Ford motor credit lien. It was about 10 years old, still valid judgment lien for like $20,000. Apparently he'd had a truck repossessed at some point in the past. It was a decade ago, kind of forgot about it, but that lien's still living there. Then that property now becomes subject to that lien because of the affidavit moving it into his name. Where if a probate attorney had have taken a different tact, opened an estate, gone through probate, and then gotten the administrator the power to sell, that lien's not even involved in the situation. Now, we were able to get with Ford. Apparently it had a payment plan years ago, and it actually paid it off, but it took several weeks to get Ford to pull their old documents, recognize it, release the lien. So it ended up just being a delay in that case instead of, being out the $20,000.
It's so much more to this than just the heirs to my estate or my kids are going to get the house. There's
right.
So many more intricacies to it.
It can be.
Yeah. So we talked a little bit too about family going into assisted living.
Sure.
Right. So do you interact with like Medicaid or Medicare at all? Because I know sometimes
we don't in our practice deal with that, but the considerations like we were talking about with the estate, they're there. These areas of law regularly overlap, and they're important considerations. So Medicare, when you go into the assisted living, Medicare looks to the assets of the beneficiary of the Medicare to try to recoup some of that cost. The biggest asset is typically the home, and that's where they will look. And you can't just, I'm going into medical, assisted living, and Medicare is going to help me pay. I can't just quit claim it over to my kids. Medicare is kind of on to that. So what they will do is use a 5-year kind of look back or clawback period where if you have transferred any assets during a 5-year period, we're going to discover that. If you didn't do it arm's length, like to a buyer and receive the money, then we're going to claw that back, that gift to your kids back. So what we will do in some situations is, people are planning for that. Hey, I'm feeling pretty good now. I'm in my 60s. I'm still gardening, but 15 years from now, I don't know what that's going to look like. Let me go ahead and quit claim my property over to my kids. I'll reserve a life estate so that I can still control everything, and that reduces that ability of Medicare to claw back that property. So that's something to think about, but that's years in advance.
Yeah, you got to plan that way ahead.
Sure.
And I guess while we're on the topic of planning ahead too, we talk about somebody passes without a will, right? You're intestate, they got to open up the court case or what have you. What happens if I do have a document, a will, and let's just say family member passes away, the will's there, I'm the executor. Now what do I do?
Right. So you're going to gather up that original will. If you can't find the original, get a copy, and you can work with that with the witnesses and the notary that are on that copy. Maybe the judge would have you bring the witnesses in, and that would not be what's called a self-proved will. In Kentucky and Ohio, you've got self-proving is a couple witnesses and a notary on the will and the signature of the testator, the deceased, and you bring that in as the executor. If you've got the original, you're going to file that with the district court where the deceased lived, and then the judge is going to appoint you the executor, and you have all the powers given to you in that will. The power to sell real estate has to be explicitly stated in there. Otherwise, you have to get that power just like an administrator by moving the court to get an order. But if you have the power to sell real estate, and most well-drafted wills will have that in it, then as the executor, you can move forward with a sale. There's no order from the court specifically authorizing it. The will itself becomes your authorization, and you can kind of move along. Now, that's kind of the legal requirements. But one thing that I like to kind of bring up to folks when I'm talking to them is, as a settlement agent, your main purpose in the transaction is not only facilitating all the information, putting it together into a settlement statement, but it's also issuing an insurance policy, both for the lender and the owner. And so it's not just the legal requirements that come into these situations, but the underwriting requirements. So insurance companies are looking at, where's our risk here? What's the potential avenues for claims that people can come in? So it's not just the legal requirement of the executor. And one main example that comes up a lot is, let's say there are more than one heir. You're the executor, you said, of an estate. The deceased had you as a child plus 3 others. Those other 3 others, we're going to ask for some written acknowledgement that they are agreeing to this sale of the property. And we get some pushback on that from time to time, sometimes from other attorneys as well. It's like, well, you don't need that. I'm the probate attorney. This is the will. The executor has power to sell. Bada bing, move on. But there's, from an underwriting standpoint, legally that's correct. But from an underwriting standpoint, you have those other heirs are potential claimants on the property.
Right.
In Kentucky, there's an old case. It's Lucas v. Mannering. I don't, for any of the people wanting to look that up.
Yeah.
But the Cliff Notes version is, the executor in an estate wanted to sell some property. She was not one of the beneficiaries of the will, though. I think it was a girlfriend of the deceased or a second wife of the deceased, some situation like that. But the beneficiaries were the kids of the deceased. So
she was administrating everything, but she wasn't getting anything from it.
Correct.
Oh, okay.
So this is where this came up. And the situation there was, she had the power to sell. She was named the executor in the will, and she wanted to sell some property that this deceased owned before he passed away to some friends for a discount price. And the heirs are obviously like, we don't want that. We want the land. You have to give us the land. And then the question before the court is, does an executor with the power to sell have a duty to the heirs, or can they just do what they have the authority to do in the will?
So what's the verdict there?
The verdict in that case was that because the executor is a fiduciary and it has to do what's best for the beneficiaries, if they're demanding the property, the executor has to will them or deed them the property from the estate. Can't just sell it and give them the proceeds. So then, because of that holding, those beneficiaries are always going to be potential claimants on an insurance policy.
I gotcha.
So based on that case alone, we reach out to all the heirs. Hey, just a quick email. Let me know you're aware that this is being sold. You agree to it. You got no problems with it.
So let me ask you this, because we have a transaction right now that Mr. Owner passed away. Months or years later, Mrs. Owner passed away. Well, Mrs. Owner's family is the executors and the administrators of the estate.
Sure.
Well, I believe one of their kids, they had two daughters that lived out of state. We're not able to get in touch with them whatsoever. And it was just discovered that they were even beneficiaries of the estate. What happens in that case? You can't even get in touch with the heirs.
So in that case, you're really going to lean on the probate court to give you your boundaries. They have warning order attorneys that are involved, and essentially what that is it's the court's way of putting out like an all points bulletin kind of thing. We're going to say, and sometimes the judge will say, let's do an advertisement in the newspaper for 30 days. Let's contact their last known address and certified letters there. And the warning order attorney then goes out, checks the boxes, and comes back before the court. Judge, we tried everything. We can't get a hold of them. At that point, the judge has some options. They can make you keep trying, or they can essentially have the master commissioner deed the property over on those missing parties' behalf. And that's a court action. So essentially what you're left with missing parties is a quiet title action. That can be handled through the probate case in a probate situation like you described, but it also comes up in a lot of other situations too.
So what would be a best practice there when you're in a situation like that? Obviously, do your homework before you put the property on the market or before things are done. Make sure you've exhausted everything. We're not going to have anything pop up here as a red flag that derails us, because if you've got a buyer planning to purchase that property and close and move in, and then, oh, by the way, 2 weeks before closing, we find out that there's heirs that we didn't even know about.
Right. Yeah, you can't always rule out the heirs, and because sometimes the deceased won't even know about all their heirs. And with the new 23andMe, these DNA programs, that situation's coming up a lot more. People are finding out, about relations that they didn't necessarily know about. And after someone passes away, somebody hears about it in the newspaper or does a 23andMe test they got for Christmas and finds out, oh, I've got, family I didn't know about. So then they hear about an estate that maybe there's some money in there, and hey, it's by law it's theirs.
It's probably not a big deal when it's a small piece of land that you can't build on.
Right.
It's not a big thing. But if somebody's got hundreds of thousands of dollars in assets, like that can really derail.
It presents a potential claim, essentially, is what it is. And as a buyer, anytime you're buying property from an estate, the only way you can really safeguard against that, you're not going to do DNA tests on the family, right, and run it through database. So you just have to get the insurance policy.
Yeah, so that's another thing that we'll talk about. Now's a good enough time because we're on it, and that is when you're a buyer, at least in the state of Kentucky and Ohio, owner's title insurance is optional.
Yep.
If you're getting a mortgage, your lender most likely is going to ask for a lender's policy, a title insurance, but in these states, owner's policy is completely optional. I usually recommend it on every single sale.
Yeah.
You never know what's going to happen.
Sure.
You'll be glad you have it if you ever need it. But let's talk about title insurance for a second. If I am a buyer and I'm purchasing from a divorce, an estate, any sort of legal red tape, let's describe an owner's policy of title insurance for people who have never run across that before.
Yeah, so like you mentioned, the lender's policy covers the lender, and that's up to the amount of the loan. So if they go to foreclose and a title problem or an heir or anything comes up that will prevent them from being made whole, that lender's policy is going to pay the lender to make sure they're covered in their interest. The owner's policy protects the owner, kind of as it indicates there, and that will protect you up to the entire purchase price of the property. And you can even purchase some enhanced policies that will continue to grow in coverage as the house appreciates over time. But a basic owner's policy is going to make sure that you're made whole as the owner should that heir show up and say, hey, the farmer who owned this property was my grandpa, and my dad was a child that grandpa never even knew about. But now I'm here to collect dad's interest. And even if the person is wrong and making it up, you're in a situation where you've got to defend yourself. And the attorney's fees in a case like that, with the forensic investigation that would be required, can run $10,000 pretty quick.
Yeah.
So just having that insurance policy provides the attorneys, even if the guy's wrong. But if it turns out he's right, you're covered there as well.
Yeah, and insurance is not a sexy topic, but
Sure.
it's one of those things where you don't have to be wrong to be sued.
Right.
And I mean, it could be any piece of land. You know, say that you built a house on a developed piece of property. Things didn't go the way they should have when the place was developed.
Right.
And they didn't do their homework. Well, somebody owned that land that didn't sign off on it. Now they want to come and collect.
Yeah.
And it's like, you have no idea. There's
Sure.
no way to know.
Yeah, it's a common misconception that new house, old house, that's relevant somehow, and it's not. I mean, what you're insuring is the land and everything on it, and the land has been there, right? Since
For a
Kentucky
long
became
time.
Kentucky, that's been that parcel of land, and before then it was Virginia, and so on and so forth. But so yeah, the new house, new division, new subdivision, old subdivision, oh, this place has been there for 50 years. None of that's really relevant as to the likelihood of a claim. A lot of transactions over time are going to introduce a lot of parties, which could produce more claims, but it also produces more transactions and more title searches,
Yeah.
which would mean less claims. So, I mean, it's really not a good basis for deciding on whether or not to purchase a policy based on how new the home that sits on the land is.
Right. Or when the last time it sold was, or
Right.
if there's some sort of legal red tape around it. So while we're talking about this, my wife and I have updated our wills twice now. You know, we had a will before kids, had a
Yep.
will after kids.
Sure.
What are the key, how often should somebody update their will? You and I are basically saying the same thing. It's like, you should probably have a will. Everybody.
It makes it easier on the folks left to clean up after you if you pass away.
Right. Does that have to be prepared by a legal person, or does it just need to be something written down that can be notarized? How would somebody go about doing that?
You've got some options. I would always recommend getting some legal guidance if you're drafting any legal document, including a will. Again, it's not going to affect you. By the time this will matters at all, you're good. You don't have any problems anymore.
Nothing to worry about.
But for the people left behind, you're going to solve a lot of problems by getting some legal advice. Again, that explicit right to sell real estate. If the only asset really you have when you pass away is a checking account, a car, and maybe your house, and a retirement account, that house is likely to be one of the biggest assets that your executor is dealing with. And if they don't have the power to sell in the will, or if there's some other clause that you put in there that concerns a title underwriter or anything like that, you've really kind of defeated the whole purpose. So I would recommend getting legal advice and having an attorney draft one up for you, but it's not required.
Right.
In Kentucky, you can do a holographic will, which just means it's handwritten. The whole thing is handwritten in the testator's handwriting. It's signed and dated. And that's it. You don't need a notary. You don't need witnesses. That can be
Good old
probated.
Kentucky.
So, and that's not really uncommon. I mean, it kind of developed as a part of like deathbed confession type wills, where people are like, hey, I know this is coming. I want to be able to direct my assets now, and I don't have a notary at the moment. And courts, want to do, the goal here is to disperse the assets of the deceased the way they want it.
Right.
So there are other ways.
So when should people do that?
Like we're talking about today, life changes. You don't necessarily have to update it every time your life changes, but you want to take a look at it or have someone take a look at it. Any major purchases, if you start a business, who's going to handle that? Where does that go? That may not be the same people that got the rest of your estate. You get married, obviously, you want to adjust for that. Kids, you want to include, a guardian for those kids. You can state that in there. And maybe even set up trusts that you wouldn't have needed before. Like if it's just me and my wife, if I pass away, everything goes to her. She passes away, everything goes to me. We don't really need trusts. We're adults. We can handle it. But if you're dealing with minors, they can't really receive the property. And sometimes even, your kids better than anybody. You might have a 20-year-old that probably wouldn't benefit from your entire life's work being dumped on them right at that moment.
Right.
And you can with an attorney, set up trusts that can kind of protect them from themselves in that instance, Until they get to 25, the only thing they can draw money for is, health, welfare, education, things like that. Then at 30, you can give them a down payment for a house or for housing needs. And at 35, they get it all, kind of thing, to stagger it, to protect them from the unforeseen.
So big life changes, wouldn't be a bad idea to review the will.
Just take a look at it for sure.
Yeah.
Is there anything in here I do want to get changed? Divorce is another big one. You don't want to leave everything to, the person ABC, and then person ABC is no longer who they used to be to you, and they could still end up with some assets.
I can only imagine if your wife opens up your will after you pass away, and she gets nothing and your ex-wife gets everything. Yeah. Like, that would be
not what you probably intended.
That would be a bad look. You won't know about it. But
sure.
Yeah. It's a bad look. So while we're on that topic, it'd be a good time to switch over from death in the family, how do I deal with it, to marriage and divorce.
Sure.
Right. So, both Kentucky and Ohio are dower states, right? So open that up for us. Yeah. What does that mean?
So, Kentucky still calls it dower and curtsy. Dower for a wife's interest, curtsy for a husband's interest. Ohio has done away with the terms and everybody gets a dower interest. They're interchangeable both places. But yeah, dower states means that the spouse of a property owner has automatic interest in the property. Now, those are called inchoate interests, meaning they're not fully recognized now because they really only come into being if the spouse passes away. But because you have that future interest in the property as a spouse, you have to be involved in any transactions. So that's if your spouse owns property and now you all are selling it, you're going to have to sign that deed, even though they got it from grandpa 10 years before you even met them, and they're on title alone. We go to sell, you're going to have to sell your inchoate dower interest as well.
We get that question a lot. We'll have a person who bought the home before they were married, maybe even before they met the person. They bought the home, now they're married, and we send over the listing contract, and it's got both of their names on there to sign the listing contract. And it's like, oh, she's not on this house because I bought the house before. And it's like, she wasn't on the house until you got married. And now, all parties need to see that she's agreeing to sell the house. The only other option would be if the spouse signs a release of dower and she doesn't need to sign off on the sale.
In
correct?
Kentucky, that's not going to do it.
Okay.
You still have to sign that deed. And that's why I recommend folks from the listing appointment get the spouse on it. And this comes up a lot in a divorce situation where you're still married, but, one spouse has already moved on with their life. We're just tying up loose ends with the courts as far as the divorce goes. They still have to sign that, even if they did a quit claim deed. Like, I'm going to quit claim this house to you. You quit claim the investment property to me. I'll go live there. You live there. We're all good, right? As far as we're concerned, I'm on title to my house. You're on title to yours. Well, if I decide to sell, I'm still going to have to get your signature because we're still technically married.
Even though the quit claim deed occurred.
Yep. I've quit claimed myself off title, but because the divorce hasn't finalized yet, I still have that dower interest.
Yeah,
still married. So you're still going to have to be involved. And I would say get them to sign the listing agreement. It just sets the tone for, hey, you're in this.
Yeah.
Get them to sign the contract
from the onset.
Yeah. Get them to sign the contract. That way you don't end up with situations like we've had several times in the past where it's like they're holding this against me. They won't come sign this because they know I need it to happen. And it just becomes another one of those wedge issues that spouses sometimes, unfortunately, in a divorce situation will use against each other. So you might as well know that you got a problem as early as possible. And if the spouse isn't going to cooperate, at least you know that. Right. And you can get an order through the divorce court that, compels the spouse to cooperate.
Right.
It also comes up in refinances. Because the spouse would have to be involved in that if you're married too, even if they're not selling, but they're refinancing the house as far as signing the mortgage. But,
right. So it's ugly when it happens most of the time, but let's talk about, okay, we're married and one of us is going to keep the house. We're going to go through with the divorce, right? So how does that come into play? Obviously, you mentioned a quitclaim deed, but then there's still
the dower interest until the divorce decree is entered. Once the parties are officially divorced, the marriage is dissolved, those dower rights go away.
Gotcha. And then as far as marriage goes, let's just say, for example, I've got a person who's going to buy an investment property, and to protect their spouse's interest, that investment property is going to not be in the spouse's name. It's going to be in one of the person's names or even an entity.
Sure.
Right. So how would you handle something like that? Like, I don't want my spouse exposed to any sort of legalities to the property. Would you advise somebody to put a property into an LLC to protect themselves and their spouse, or would that be could I just put it in my name and get a nice general liability insurance policy, or it's all situational?
Yeah, you can do it either way. I do recommend if you're holding a piece of real estate for the purposes of investment or a business, let's run it like a business. So, that does include the limited liability protection. Now, when I say run it like a business, that's part of it. A lot of people will think, oh, I'm buying a rental house or an Airbnb. We're going to put it in, Aaron Smith Airbnb LLC, and I don't have to worry about it anymore. And then you just keep transacting like it's your property.
Mm-hmm.
The ceiling fan needs replaced. Well, Aaron goes to Lowe's and buys it. That's all doable. People do it, but you're interrupting that treating it like a business.
Mm-hmm.
And when the rubber hits the road and that lawsuit shows up, the judge is going to look to, well, is this a business, or were you just made a filing at the Secretary of State's office and did a quitclaim deed into it? Because that's not going to cut it.
There's so many investors that I see that commingle the funds.
Right.
And like you said, when the rubber meets the road and there is some sort of legal action taken against you, that's called piercing the corporate veil.
Absolutely.
Your legal liability corporation matters because you didn't treat it like a business. You treated it like it was just your own personal property.
Yeah. Get accounts, put the rent in the LLC account, damages, fix things out of the LLC account, pay the landscapers, whatever out of there, run it like a business, and you'll enjoy that limited liability protection should the worst happen. Now, you're still going to want that general liability insurance policy to, that's a big asset.
What is if I'm an investor, what does a general liability insurance policy protect me against? Somebody slips and falls down the steps because I didn't salt them?
Well, you're going to have a homeowner's insurance policy, and that's going to provide a pretty good level of coverage for your run-of-the-mill stuff. Something happens to the home, somebody slips and falls coming up your steps because of some defect in the house. You're going to have some personal injury protection there as well, but that general liability is going to provide kind of an umbrella for, if it breaches the limits of the coverage of the homeowner's insurance policy. It's also going to cover you in a lot of cases. It depends on the policy itself, but a lot of cases you can get some employment practices coverage. So if somebody sues you for discrimination even, it would provide the attorneys to defend that suit. So and like with most things legal, the devil is in the details there.
Right.
So you want to really go through it with your insurance agent and kind of say, here's what I'm concerned with, and what is covered, what isn't covered. Am I covered for discrimination? Am I covered for an injury on the sidewalk? That's more common than you would think. People out walking their dog and they trip over a stick or a break in the sidewalk, and they've got months of therapy on a knee. Well, who's paying for that? It's the homeowner. And people don't realize that. It's like the city put the sidewalk in, but the homeowner is responsible for it. It's on their property. So, and if you've got an investment property, same would apply. You've just got more risk there because you've not only invited someone onto your property, but you're collecting rent from them. So you have some heightened duties to protect them. And if something were to happen, which, the unthinkable happens, you want that coverage.
Yeah. Yeah, nobody wants it to happen, but it could always happen, and that's why putting the proper steps in place before these things happen.
Sure.
Not thinking about it, I should have had a general liability, or I should have bought title insurance, that sort of thing. So that covers a ton of when life happens kind of stuff. But I'm sure as a title attorney and closing services provider, you run across things all the time where, man, I wish more people knew about this, or it would make everybody's life easier if more people knew about this or took these steps. Anything comes top of your mind? So
one of the things, setting up the will, that's a big one. We kind of covered that. Another one thing we see a lot, and it's more from an agent perspective, is to identify the property well. A lot of folks think, well, that's the address. That's what we're selling. And what we do see a lot that can delay or even derail a closing is that the property's not fully identified, or it's more than identified, meaning you're only selling this piece, but it's still one larger tract. So as much work as you can do up front to really nail down with the PVA parcel number, doing some PVA research, making sure that you know who the owner is a big one, because sometimes there will have been an estate that was never done before, and the person is living in their parents' home, assuming it's theirs, and that can cause some things. So just that upfront due diligence, and we partner with all of our referral partners, both loan officers, real estate agents that we work with. We want to be a part of that team with them, and as a part of that, we welcome those phone calls on the way to the listing appointment. Hey, I'm going to see, XYZ on this property at 123 Main Street. Do you care to take a quick look and see what I'm walking into here? And we're happy to do that, because it's not only going to save you guys time down the road, it's going to make you more informed when you're speaking with your client, more likely to get that listing in the first place. Kind of sets you up as the expert in the room. It's like, wow, you just showed up and you know more about this place than I do.
Yeah.
And that's the tone you want to set, because like we've talked about, you're going to have to walk these people through, in certain circumstances, bigger life events than even a real estate transaction.
I may have brought this up months ago when we met, but last year we had a client who, let's just say that they were ailing, and they were of sound mind. They had family members around them who were of sound mind. In hindsight, I wish somebody had brought up the possibility of deeding that property to them while they were sick, or working on some sort of power of attorney document. And power of attorney doesn't really protect you if somebody passes.
Correct.
Right?
Yeah,
that's done and over.
It would pass with the principal in that case.
Right. But let's just say, for example, I'm an agent, or I'm a consumer out there, and we're about to sell a home, and the person that I'm, the person who's selling the home,
end-of-life situation.
They're in an end-of-life situation, or it's possible that they may be in and out of being coherent, and they may not be coherent much longer.
Right.
Is it possible to get a power of attorney or a limited power of attorney so that somebody can handle those things in the case that, hey, mom has her good days and bad days. There's a possibility she may not be sound mind to do what she's saying she wants to do right now, so we want to carry it out for her? Or
well, in order to enter a power of attorney agreement, you've got to have that same competency.
Right.
So the principal is going to have to know what they're doing, know the assets at stake, and know what they're allowing this principal or attorney, in fact, the person who would be signing for them, know what they're allowing them to do. And if you have that knowledge, then yeah, you could enter that agreement. But it's going to be the same level of competence to execute the real estate transaction. So if you don't already have that general durable power of attorney in place, it may be too late to get that.
Gotcha.
If you're in those kind of borderline situations, and like these are all spectrums and gray areas there, I would just recommend getting all the interested parties involved. Have all the kids. Maybe if you are doing a mom situation like that, have her, have 3 power of attorneys. All 3 of her children make those decisions together. And then if there is some question about competence, it's less impactful because you've got everyone that would have a claim involved to make the decision. So you've got nobody to argue or complain.
That's good advice. And these are things that we don't think about until they hit us.
Right.
So that's what I'm trying to do, is get people to think about these things ahead of time before they get behind the 8 ball, so to speak. So.
And they're tough conversations, and that's usually why they get behind the 8 ball. Sometimes you're more likely to do the good conversation than the tough one. And if Uncle Frank has been estranged from the family for years and he's an heir, you probably ought to bite the bullet, go ahead and give him a call up front, as opposed to waiting till closing and hoping he sends the deed back.
Uncle Frank's just a jerk, man.
Yeah, you never know. They come up, man. We see Uncle Frank a lot.
I guarantee you see Uncle Frank a lot. Awesome. Well, this has been great. So thank you guys for watching the Real Estate Momentum Podcast. This has been Jodie Tharp. He's with Holbrook and Holbrook Title. Thank you, man.
I appreciate it. No, it's been great to talk. It's always good to see you, Aaron.
Yeah, you too. Thanks for watching, guys.